Recording in progress.
Good morning, honourable members. Welcome to the meeting. I just want to firstly verify which members are in the meeting. We have Honourable Duduvu, Honourable Bartlett, Honourable Dlamini, Honourable Maleka, Honourable Ndongeni, Honourable Kadebe, Honourable Badenhorst, and Honourable Mikalakis. I hope I haven't missed out any other honourable member. Okay, I don't think I have. But once again, honourable members, welcome to this meeting. Just in terms of today's agenda, we intend to continue our deliberation on the Electoral Matters Amendment Bill. On the platform as well, we do have, I see the Deputy Minister of Home Affairs. Welcome, Deputy Minister. And I would imagine that your legal team as well would be present on the platform. I hope I'm not missing. Okay, and Parliamentary Legal Services, welcome to the meeting. I hope I'm not missing. Oh, okay, and we also have representation from the IEC. Let me welcome the IEC as well to the meeting. My apologies for honourable members. The names do jump a bit as people join, so I'm just trying to be thorough. Thank you very much. Let me welcome everybody again. As well as if there are any other officials on the platform, they are welcome to this meeting. On members, in our last meeting, which we held on Friday, the 15th of March, we deliberated on the bill and we discussed each clause where public comments were made and amendments effected by the bill effected to the bill by the Portfolio Committee. Clause 29 of the bill, which deals with amendment of Schedule 2 of the Political Party Funding Act, Regulations and Political Party Funding, was also given more attention in that meeting. The clause deals with the proportional and equitable party funding allocation, as well as the upper limit donation and disclosure limit, where prescribed amounts were removed from legislation so that they are reflected in regulations. Members will recall that there were different views expressed by the committee members on this clause. While there was support expressed for the 90-10 proportional equitable allocation, clarity was sought as to whether the percentages of the proportional and equitable funding allocation was a substantive amendment, whether this will require further public participation on the bill, and whether this was against Section 236 of the Constitution. Furthermore, issues were raised in terms of whether the removal of the prescribed amounts for upper limit donation and disclosure limits will render the Act ineffective until such limits are set in new regulations, and further how the department will ensure that the regulations are drafted timelessly so as to avoid a gap in regulations with reference to the prescribed amounts. What is also raised was the NA resolution in this regard. And members will recall that there were responses to these concerns by the Deputy Minister, the legal representative from the department, as well as parliamentary legal services on the matters that were raised in that meeting. Members, I'm going to once again open up for members. If you have any further questions or concerns, issues that you would want to raise in terms of further deliberation on this bill. And if you can just please give me an indication if you have any additional issues that you would want to raise.
No, there's no addition that you want to make, Chair.
Honorable Bartlett, okay, I see the hand of Honorable Badenhorst. Honorable Badenhorst.
Thank you very much, and good morning to the colleagues in the committee and everybody attending the platform. Apologies for my video not being on. I'm saving bandwidth. Chair, I think we've got to be very careful in your summation of the meeting on Friday the 15th. You just mentioned that there's general support for the 90-10 split, and I think we just got to be careful not to generalize, because
let me just stop you there, please, Honorable Badenhorst. I think it's very, you should not misquote me in terms of what I said. I said that there were different views expressed by the committee members in this clause, and I said that there was support expressed for the 90-10 proportional equitable allocation to political parties and independent representatives. There was a view on that. So that's all I'm saying. I'm not saying there's general support, but please continue. Thanks.
Thank you, Chair. You're welcome to interrupt me. You are the chair of this meeting, so
I'm not interrupting you because I'm correcting you. Please continue.
That's fine. I'm happy to go back to the recording of what was said so far. I heard that in general the 90-10 principle was supported. That's what I heard, and that's why I made the comment.
Be it as
it may.
Please continue.
Thank you, Chair. Thank you. Be it as it may, allow me to continue. I think we just got to be clear here on the DA's viewpoint, and I have forwarded some notes to the Secretariat. I'm hoping that it'll be included as a minority view. The main overall objection of the two clauses that we're talking about here, the party funding allocation and the regulations on disclosure threshold, so both clause 29, we feel is not relevant to amending the laws to include independence. We feel this has been a rush process, and just because of the elections looming, and because there's been delays on the introduction of this bill, which means that these clauses have now not been properly considered. Let me deal with clause 29 first, the party funding allocation. So clause 29 increases the proportionality of the allocation from 66.6% to 90%. And it decreases the equitable allocation from 33% to 10%. So Section 236 of the Constitution, Honourable Chair, and I say this again, and I quote, national legislation must provide for the funding of political parties participating in national and provincial legislatures on an equitable and proportional basis. So Section 236 is very clear that this must be done to enhance multi-party democracy. This proposed clause goes against the tenets of the Constitution, and the change is purely to benefit the ANC coffers. This is the effect of an extra 50 million rand going to the ANC in the next year alone, while smaller parties' income is drastically reduced. As independent representatives are limited to one seat, their allocation would be more than halved. The DA proposes that the funding model currently used remains and that a proper investigation is done into party funding allocation before these laws are amended. To get back to clause 29, the regulations on disclosure threshold and the upper limit on donations. So clause 29G and H amend the regulations by removing the set amounts. So this is 100,000 rand on the threshold for disclosure and 15 million rand on the donation limit. The clause reads that the president must make regulations on upper and lower limits, acting on the resolution of parliament. So the DA does not oppose the clause for its substance, but based on the practical situation that it may create. We have a situation where there will be either a delay in these clauses being brought into effect, or we'll see another rush parliamentary process for the resolution to be passed. We could even have the scenario where the bill is passed in its entirety with no precautions taken, resulting in no limits on donations or requirements for disclosures. So the DA proposes that to simply add the existing thresholds to the new clauses to ensure provincial precautions are taken, provisional precautions are taken. So, Chair, I've sent this through, the notes through to the Secretariat. We will support the report if this can be included as the minority view from the DA. But we oppose the bill. Thank you very much.
Thank you very much, Honorable Badenros. I think you raised some of these issues in our last meeting as well. Although I guess you're coming up with much more clearer proposals that you want to put into your minority view. Okay, I see Honorable Dodovo's hand is up. I'll take your viewpoint, Honorable Dodovo, but also I would want the department, the IEC, as well as the parliamentary legal, if they have anything also to add. Honorable Dodovo. Honorable Dodovo.
Yes, thank you very much, Honorable Chair. Honorable Chair, we are left with about 8 weeks or so before the elections. And as members of parliament, especially from this committee, we need to be extremely concerned that we are where we are because we have not yet finalized the amendment to the electoral law as an imperative of the Constitutional Court. And my plea is that whatever that we do must be an endeavor to ensure that we finalize this particular process. We're coming a long way, a long way in terms of this bill, the Electoral Amendment Bill. It has been back and forth movement. And at some point, we need to really finalize this. I feel that we want to shift the goalpost. This proposal of the funding model, it is quite appropriate. From our side, we looked at it, we have researched it. We think under the circumstances, it is okay because of its dual nature. It caters for equitable funding as well as the proportional funding. It is sufficient, and an impression must not be created that we have not investigated, and therefore whatever that is on the table will require further proper investigation. From our side, we've done our homework. We have investigated this. We are satisfied, more than satisfied, that under the circumstances, this is what our country needs. And I think we need to really move forward in respect of this particular matter. And also, it adds to the fact that the existing threshold, it is also really, really sufficient in terms of how we should really move forward. And with the work that we have done, our firm proposal is that we are okay, we are resolute. Let us finalize this process, comply with the order of the Concord, ensure that South Africans are ready. The IEC, our electoral body, is also ready. It does what is expected of it without any impediment. What is important is that as political parties, let us go on the ground. We are ready. Let's go and fight the elections and not create unnecessary scapegoats and reasons why we should delay this particular process further. Our view is that as the ANC, we are okay. We support the current proposal that is on the table as contained in the bill, and let's move forward. Thank you very much.
Thank you very much, Dogo. Honorable Bartlett. Oh, Honorable Kadebe, sorry. I see your hand. Honorable Kadebe.
Yes. Thank you so much, Honorable Chairperson. Yes, I just want to place it on record that we, as the IFP, are also opposed to the amendments. Our argument is more or less the same as the DA argument. We support, in essence, what the Democratic Alliance has indicated. Not that we are afraid of the elections, Honorable Chairperson, but because we view the amendments in a sense that it has got an element of unfairness and impracticality. But having said that, I want to stress that it is not because we are afraid of the elections. I mean, the country knows that since the 2021 local government elections, the IFP has snatched 15 wards from the ANC in the province of KwaZulu-Natal. So, but we would not want to go to the elections with our eyes closed to allow such amendments to proceed. Thank you, Honorable Chairperson.
Thank you very much, Honorable Kadebe. Honorable Bartlett.
No, Chair, I'm fine. I concur with Comrade China and the support his idea. I don't want to repeat what the other honorable members have said. Thank you, Chair. And just to emphasize, this is not because of election, this is because of the bulk of work that we must still do and need to finalize. Thanks, Chair.
Thank you, Honorable Bartlett. Honorable Maleka.
Thank you, Chairperson, and good morning to everyone in the platform. Chairperson, I want to concur with what Honorable Totovu said. As we are all ready, and there is no party that is going to be on the election with the eyes closed. We are all our eyes are open. Let us support as the ANC, we support all the amendment that has been tabled to us. Thank you.
Thank you very much, Honorable Maleka. Let me then just thanks all members for all your views expressed. I'm going to allow perhaps the department if they have any additional responses that they want to make in terms of some of the issues that were raised. I'll start with the DM for Home Affairs, or the legal person, legal representative from Home Affairs. I don't see them on the platform, but okay,
Thank you very much, Chair. Yeah, thank you very much, Chair. And please do excuse us. We had to split ourselves because other department officials are attending the portfolio committee that is ongoing right now. There isn't much to add, but just to emphasize that the amendments that we're dealing with are consequential because the introduction of independence requires us to review the funding formula, so they are consequential. Secondly, the Constitution, Chair, does not prescribe on the percentages of what ought to be equitable and what ought to be proportional. And it dictates that our logic and our thinking is what must then prevail. Lastly, Chair, we are faced with the issue of time to resolve and finalize this particular issue. And I will really plead with the select committee that we try and conclude with speed. But as a basic, amendments are consequential. And on the issue that is of the bone of contention around the funding formula, the Constitution does not prescribe what percentage. Is just prescribed that it must both be equitable and proportional. And that is what we have done. Thank you.
Thank you very much, DM. I think I saw the chairperson of the commission, Commissioner, welcome. I think when I started the meeting, I did not note you on the platform. But let me take this opportunity to welcome you, Commissioner Mwebia here. I just from the side of the IC, any comment?
Good morning, Chair, and honorable members, Deputy Minister as well, and my colleagues. Sorry, Chair, we were also in the other committee and I had to run into this committee, and sorry for my delayed joining. We do not have anything to add to what has already been indicated. We have simply not been here as South Africa at this time, with an election before us and some amendments still outstanding. And so this is the only thing that we have to deal with from where we are. And we trust that the committee will deal with the amendments as may be appropriate. I thank you very much. I don't think we have any additional issues to raise today, Chairperson. Thank you.
Thank you very much, Commissioner. From Parliamentary Legal Services.
Hi. Thank you, Chairperson. Yes, regarding those two issues raised by Honourable Badenhorst, the first issue being whether the amendment was substantive versus consequential. Just to reiterate Parliamentary Legal Services point of view, initially we had said that it was a substantive amendment and that we raised the principles in Harkson versus Lane, that if a provision differentiates between people or categories of people, that there should be a rational connection or legitimate government purpose. And in doing so, we'd like to reiterate also, Chairperson, that it is the prerogative of the executive to develop policy, and then it is up to Parliament then to interrogate the policy, which Parliament did in the Portfolio Committee. And for this reason, this is why the Minister then brought figures to that Portfolio Committee, which presented figures that the 90-10 formula had, in their opinion, disadvantaged independent representatives, and then presented further figures with the new formula that the 90-10 did not disadvantage independent representatives, and in fact assisted independent representatives. It was more fair to independent representatives in the Minister's opinion and in the department's opinion. And I think it was based on this presentation and this interrogation by the Portfolio Committee of the policy of the department that the decision was made to make the amendment or to approve the amendment. And then secondly, regarding Honourable Badenhorst's concern with relation to the lacuna or the gap in the law that will happen once the the amendment bill is promulgated by the president. Yes, we are aware of that. We have highlighted it to the chairperson of the portfolio committee and to yourself, chairperson. And in doing so, we have made steps to mitigate the risk of there being a lacuna by informing the speaker. And I think my colleague, Advocate Van der Merwe, has alluded this committee to that, and that we trust that the speaker will move with haste, and that we will have a resolution presented by the NA as soon as possible in order to make those regulations happen as soon as possible. Thank you, Chairperson.
Thank you very much, Parliamentary Legal Services, Talana, for the input. Thanks, honourable members. Okay, I see Honourable Barnos, your hand is up.
Yeah, if I may, just based on what the legal department just shared with us, it might be helpful for us to know what those recommendations were to the Speaker of the National Assembly.
Okay. Yes, Talana.
Chairperson, Chairperson, through you, we alerted the speaker, we alerted yourself and the portfolio committee chairperson that there is a possible lacuna that may arise, and that it is necessary that a resolution be passed as soon as possible. We are mindful of the programming of the National Assembly, and that the legal opinion just basically alerted the speaker to the fact that there might be a possible gap in the law should those regulations not be drafted as soon as possible, and that also bearing in mind that the regulations needed to be drafted on a resolution by the National Assembly.
Okay, no, thanks. I thought you explained that as well earlier. But thank you for that additional explanation to this. No, thanks, honourable members. I think members have expressed their view. The DA has requested that if we move ahead with the process, they obviously have a minority view that they've provided to the Secretariat. And okay, honourable members, let me open it up once again if members have any other issue, because then we can conclude the process today. Okay, I'm not seeing any hands being raised, but I should just also indicate also that in our last meeting as well, I did raise the issue that provinces were requested to respond, especially in terms of the financial management issues with regard to
Lost you, Chair. I think you're muted.
Members, we seem to have lost the chairperson. I'm just going to try and contact him.
Sorry, honourable members. I don't know how I got muted. But in essence, we received just responses, as I said in the last meeting, from KZN and Limpopo, and I think both provinces indicated that they had no concerns in relation to the bill. But let me take this opportunity, honourable members, to thank you, thank the department, the IEC, legal advisors, and the officials for their attendance and engagement in today's meeting. So, honourable members, we will then, in our next meeting, which is going to be tomorrow, then take the process forward, looking into the adoption of the bill, as well as the report of the committee. And I think with regard to what was raised around the steps to mitigate the lacuna, I think we trust that the Speaker will move with haste and that we have a resolution in place. Thank you very much, all members. The meeting is adjourned and we'll meet in the next meeting. Thanks.
Thank you, Chair.
Thank you, Chair.
Thank you, Chair, and thank you, members.